The Bondi shooting was a crime so shocking, the entire world stopped, watched, and waited. And then nothing seemed to happen. In December 2025, a mass shooting event at Bondi Beach shattered lives and left Australia asking how this could happen and what justice is supposed to look like afterward. Almost immediately, another question followed it everywhere. How does our legal system manage these cases? Today, I'm going to walk you through what actually happens next in court and why it takes so bloody long to get an outcome. By the way, if you're new here, my name's Haider Shakara. I'm an Australian lawyer, a TEDx speaker, and I like to break down legal concepts for people to understand. So if you do find this video useful, please give it a like and subscribe to the channel. All right, what do we know so far about the Bondi shootings? On a normal Sunday in Sydney, the 14th of December, a terror attack occurred at Bondi Beach that left 15 people dead and dozens injured. The attack involved two gunmen, a father and a son, Sajid Akram and Naveed Akram. Sajid Akram was shot and killed at the scene by police, but the son, Naveed Akram, has survived and after being hospitalized, has been formally charged. Naveed is facing 59 charges, including 15 counts of murder, 40 counts of attempted murder, a Commonwealth Commit Terrorist Act charge, plus firearm and explosive related offences. The prosecution case alleges not only mass killing and attempted killing, but that it was terrorism, meaning that this now moves away from a state case and it moves to be prosecuted by the Commonwealth Director of Public Prosecutions, even though it's running through New South Wales courts. And that's what happens when it becomes a terrorism charge. Now, what has already happened in court? Naveed's first appearance happened shortly after charges were laid. It was in the local court at the Downing Centre in the city of Sydney. It wasn't a full-blown hearing with witnesses and cross-examination, just because it was very early on. So in early appearances, they're normally administrative. They confirm the identities of who's there. They note down the charges. They deal with any bail issues and they set dates for the next steps as to what's going to happen with the evidence, with the defense, and whether or not a trial is going to be occurring. For Naveed's case, no bail application was actually made and bail was formally refused. This means that Naveed is to be held in prison until there is any further judicial determination on the matter. Now, before we go any further, let's address the question a lot of people are already yelling at their screens. Why do we even need a trial? There's video evidence. There are witnesses. We've all seen the footage. Isn't it obvious? Isn't this just a massive waste of time and money? When something is this confronting, this public, and this well documented, it feels like the answer is right there. Case closed, move on. We don't need to deal with this. Let's lock him up for life. Isn't that what's going to happen anyway? But the legal system doesn't work on outrage. It works on proof. It works on procedure. It works on rules that apply every single time and time again. It doesn't matter who the suspect is, doesn't matter what the evidence is, doesn't matter how overwhelming it all is. It needs to go through the proper process. That's what the system's based on. Video evidence doesn't just replace a whole trial. It becomes a tiny piece of evidence of the whole story. Now, a big question that we have no understanding of right now is, how is Naveed going to plead? We don't know whether he's going to plead guilty or not guilty, and that single decision, it changes everything about how this case is going to unfold. It changes the structure, it changes the flow of the court dates. If he pleads not guilty, the legal system goes into full trial mode, and that means months, sometimes years of preparation. You've got things like selecting the jury, you've got expert witnesses that need to be called on, you need evidence that's going to be picked apart frame by frame. You're going to have the defense that's put on, including what Naveed says about what he thinks occurred during that time, and of course the police case as well. And each piece of evidence will need to be scrutinized by the court, by the jury, so that a decision can be made as to whether or not Naveed is guilty and he did commit the actions that the police are saying that he did. If this happens, you can be sure that there are going to be a huge amount of legal arguments about what the jury is allowed to hear and what must be excluded. But if Naveed does plead guilty, the entire shape of the court processes change overnight. There's no jury trial. Instead, the focus shifts to sentencing, and the court hears evidence about the impact on the victims, the scale of the harm, the background of the offender, whether he had any previous offenses, and all of the legal factors that determine what the punishment should be in a case like this. And again, whilst it might seem quite basic, These sentencing hearings can also take quite a long time to figure out because there's also a lot of evidence to accumulate for the judge to make a decision. Sometimes sentencing hearings can be some of the most detailed and intense proceedings because it's how a judge is going to determine what the accused is going to be doing for the rest of their lives. So all of the evidence needs to be out on the table as to how this person should be sentenced. So reminder, at this stage, we don't have any idea which direction this is going to take. I imagine Naveed's lawyers are going to need to see the full brief of evidence first. They need to review, they need to challenge parts of it, and then they need to advise their clients properly based on what is in the brief of evidence. So when people ask, why are we even having all of these court dates? This is a big part of the answer. Until the plea is known, the court has to prepare for every possible outcome. Another potential outcome that I think is quite likely is having some charges that are contested and some that are uncontested. Once the plea is entered, you'll see the court process shift very quickly in one direction or the other. If it goes to a trial, then it'll be up to the police to prove beyond reasonable doubt that this specific person committed these specific crimes. And in this case, this might actually be quite difficult because it would be very hard to differentiate whether Naveed or his father committed specific murders or attempted murders. So the evidence is going to have to be really clear because I can guarantee it's going to be scrutinized. Another thing to consider is this trial is going to cost a lot of money. The court's time, the police's time, the police's lawyers' time, the lawyers for the defendant's time. All of that is going to be funded by taxpayers. And a lot of you are probably thinking, that sounds like a huge waste of money. But I think the alternative is far worse. And that's when you have a system where the government can just imprison someone for life without proving its case properly, just because the public is convinced. And that's not a society that I would be comfortable living in. And that's why, as lawyers, we are all firm believers in the rule of law and following the legal process. All right, so moving forward, the next key date for Naveed Akram is 8th of April 2026. The court ordered the prosecution's brief of evidence to be served by that date. And the brief is basically the prosecution's big compiled package of all of the evidence: witness statements, forensic reports, CCTV footage, any phone records, any lab results, everything that they intend to rely on to prove their case. And in a matter of this scale, with that many charges, it's going to be an enormous file. Now, once that brief is served by the 8th of April, it doesn't mean that the trial then starts on the 9th of April. It usually means the next phase starts: disclosure, analysis, expert conferences, further evidence potentially, and a lot of pre-trial applications which are going to determine what evidence is going to be allowed in. Also, Naveed and his legal team are going to have the ability to go through that whole brief, take notes, review, and decide what position they're going to take, whether they're going to contest those things or whether they're going to plead guilty. This is also a bit of a junction where potential mental health issues, if they are raised, they start becoming relevant. Now, I'm not saying that that will happen here. It's a possibility, but I'm saying that these are common legal junctions, and in very serious matters, these can arise and they can affect how the shape of the case is unfolding. Now, there is another complicated layer to this case, and that is the terrorism charge. And that is a Commonwealth offence, and that's why the Commonwealth Department of Prosecutions is going to be running the prosecution. And as I mentioned before, it is still going to be heard in New South Wales Court, which is what you can do even though it is a federal charge. And we don't see these terrorism charges appear often. So what that means is you're going to see an extra level of complexity around classified material, around sensitive material, around potential intelligence sources, because they're all going to be wrapped around the bundle of potential national security issues. Now, courts have mechanisms in place to manage that. They could have potentially closed hearings for certain issues, whether it's got to do with access, whether information should be disclosed to the public, whether particular documents need to be redacted. And as you can imagine, all of that is going to lengthen the potential duration of these court events. Now, I want to zoom out for a moment because court events aren't the only formal processes that may follow something like this. We're already hearing a lot of talks about a royal commission, whether that's going to happen or not going to happen. But separate to the criminal prosecution, there can also be broader government reviews, processes, asking different types of questions. It's not about what Naveed Akram did, but it's more about reviewing what processes we need to reform, what we missed, whether anything else can be done to prevent this situation from occurring again. So right now there's been an independent Commonwealth review that has been tasked with examining different aspects of the federal intelligence, different aspects of the law enforcement in the context of that attack. And the results of that are going to be out in April 2026. And this isn't a criminal trial, but it's more about how policy is going to be shaped into the future. And in New South Wales, there's already been public moves towards changes in the law, particularly around firearms and community safety. And this was triggered solely because of the attack that occurred in December. I don't think it was on any government's radar to start legislating extra conditions for gun laws, gun ownership, but now that is a huge focus for the New South Wales government. So you've got multiple tracks running at once. You've got the criminal case in court, you've got broader policy and review processes that are happening, and again, a potential Royal Commission. So yeah, I get it. It can be hard for people to digest that things take so long and things move slowly. And sometimes it can feel like speed is equatable to justice. But rushing a case like this, it really just increases the chance of making mistakes. It could cause potential appeals, retrials, and sometimes outcomes that don't stick. So in matters like this, the details matter, because the consequences are so enormous. All right, guys, so thank you all for watching. Drop your questions in the comments. And if you're watching this because you were personally affected by the events, I'm genuinely sorry. Take care of yourself and please lean on support where you can. Thanks for watching, and I'll see you in the next one.